Good afternoon. My name is John Chivis, attorney with the Chivis Law Firm. I've been a participating attorney with Texas Legal for the last 10 years. Texas Legal is a statewide, nonprofit legal benefit plan that was founded by the State Bar of Texas to better meet the legal needs of Texans. Texas Legal provides members with access to over 400 network attorneys, and Texas Legal offers various insurance plan options. With Texas Legal, representation for divorce could be covered up to 100%. Contact information for Texas Legal will be in the comments box and description of the webinar. Please contact Texas Legal for any more information on the plan benefits. So today I'm going to be discussing briefly the divorce timeline and how long you should expect your divorce case to take. By the way, if you have any questions during the presentation, please feel free to post them in the comments section. I'll start by saying there are two different basic types of divorce cases, and the amount of time your case will take depends on the type of divorce case you have. Before I get to the types, no matter which type of divorce case you have, there is an automatic 60-day waiting period on all divorce cases. So even if your case is totally agreed, you'll have to wait 60 days from the time the case is filed before the judge can be presented with your final documents. This 60-day waiting period is often referred to as the cooling off period. So let me first talk about the uncontested divorce. And here's generally how the uncontested divorce will go. First, you'll fill out a client information sheet with your attorney's office. Next, you'll provide any necessary documents to your attorney's office. The attorney will then prepare what's called the original petition for divorce, and your attorney will file the petition with the district clerk's office. Next, you would need to give your spouse notice that the case was filed and exchange any necessary financial documents and information with your spouse. Now, this would be an uncontested case, so your spouse would not get served with a process server necessarily. So your spouse will need to respond. And if your spouse agrees to the basic terms of the divorce, then your attorney will prepare what's called the final divorce decree. If your spouse does not agree on an uncontested case to the basic terms, then usually if the parties are amicable, they can discuss and agree and come to some type of a compromise. Now, as I mentioned earlier, there is a 60-day waiting period during all divorce cases in Texas. But during the 60-day waiting period, this is a good time for the parties to consult, compromise, and negotiate the terms of the final decree. Once the parties agree on terms, then your spouse would be provided with some documents to sign. The first document is called the waiver of citation, and this is where your spouse agrees not to be served with a process server. The next document, which is the most important document on a divorce case, is the final divorce decree. And that's an order from the court that stipulates the terms of the divorce, property division, visitation schedule, etc. Next comes to finalizing your divorce. Now, on an uncontested case, once the 60-day period has elapsed since the filing of the petition, the case is technically ready to be finalized. Then next, both parties would sign off on the final divorce decree. Once the parties sign the divorce decree, the case is ready for a hearing. Next, your attorney would schedule a hearing on what would be called the uncontested docket. And right now, most courts allow submission of the documents to the court electronically without the necessity of even having to appear in person or virtually. Some courts do require a virtual hearing, and if required, your attorney will provide the details. However, most hearings, even if they are in person or virtual, they take less than 5 minutes. Next, the judge will sign off on the divorce decree, either by electronic submission of the documents or at a virtual hearing. And once the judge signs off on the final decree, the divorce is official and concluded. At that point, either you or your attorney can request a certified official decree from the district clerk's office. So generally speaking, in my experience, uncontested cases lasts usually between 2 to 4 months. Now, there are some comments that have popped up in the comment section, so I'm going to take a look at those and see if there's something that I can answer. Okay, I don't see any. Okay, well, there is one question. So the question is, do I need to have my own attorney, and does my husband need to have his own attorney? That's a good question. And the answer is no. Only one party is required to have an attorney, or actually neither party is required to have an attorney, but it is best if there is one attorney for one of the parties. But your spouse does not need to have an attorney. The attorney's office can prepare all of the documents and provide those documents to your spouse. If your spouse agrees, then your spouse would just simply sign the documents, and it would be as simple as that. However, it's not a bad idea to have your spouse have an attorney's office review the documents. But to answer your question, no, both parties do not need to have an attorney, and technically neither party needs to have an attorney, and a case can be filed pro se. There is another question that popped up here. Can you go over the first documents you mentioned again? Okay, well, I guess the person is asking about the waiver of citation and the divorce decree. On a divorce case, whether it's contested or uncontested, the most important document is going to be the final divorce decree. Okay, and that's usually a long document, especially if there are children involved. The waiver of citation, on the other hand, is for the responding party, and that's basically they're waiving their right to be served with a process server. The final divorce decree, again, is a very, very long document, and it lists all of the terms of the divorce. It lists the visitation schedule for the children, the property division, and everything else that's involved, all of the terms of the divorce. And that is, again, the most important document, and it gets signed typically towards the end of the case. And then once the judge signs that document, the divorce is concluded. So I'm going to go and talk about now the contested case. Contested case is a lot different, and it takes a lot longer, especially if there are children involved and custody is being disputed. So first, to start the contested case, it starts just like any other case. You'll fill out an information sheet with your attorney's office, provide the necessary documents to your attorney's office. The attorney will prepare your original petition for divorce, file your petition with the district clerk's office. But this is where things get a little bit different. Again, on a contested case, you will have to give your spouse legal notice of the filing, and you do that with a process server. So a citation and a copy of the petition is delivered by a process server directly to your spouse. Now, sometimes that is not possible. Maybe the spouse is missing, don't know where the spouse is at. There are other methods and procedures that can be used if a spouse just takes off and you don't have an address or a place to serve the spouse at. But typically, we would serve the spouse with a process server. Now, once the spouse has been served, the spouse will most likely, in a contested case, hire an attorney and file an answer. And an answer just lets the court know that the respondent, the other party, is aware of the lawsuit and they are participating in the process. Now, as I mentioned before, there is a 60-day waiting period on all Texas divorce cases, and that's whether the case is contested or uncontested. But on a contested case, it actually allows for some time to do some very, very important things. One of those things is discovery. On a contested case, there's going to be a substantial amount of discovery. And discovery is basically when both parties exchange detailed financial information, records, and other divorce relevant materials. The attorneys and clients will then review the discovery documents and typically create an asset and debts chart so that the property division proposal can be drafted. Typically, at this point in a contested case, the attorneys will float back and forth different proposals to see if how far apart the parties are and see if there is some type of an agreement that can be reached. Usually there are some remaining issues which the parties are unable to agree upon. Now, finalizing a contested divorce case is a little bit tricky. Most cases, in my experience, will end up going to mediation. And just depending upon what the issues are, there can be several mediations. But I'm just going to talk generally about how most cases will go through the process. Typically, again, the attorneys will set a case for mediation. The mediator is usually an independent family law attorney who will listen to both sides and then help guide the parties to a possible compromise. Mediations typically last for about 4 to 8 hours. And in most instances, most cases, probably 80 to 90% in my experience, the cases are resolved at mediation. Keep in mind that the mediator is not a judge. The mediator can't make any decisions, but once the parties agree to the terms in a mediation, the terms are transferred to a mediated settlement agreement, which is then binding upon the parties. If the parties do not reach an agreement in mediation, then the case will proceed to trial. Again, I'd probably say that only about 10, maybe 15% of the cases go to trial. Most parties are able to reach an agreement at the mediation. But if the parties, again, do not reach any type of agreement, whether through mediation or just informal mediation, then again, the case will go to trial. Now, trial. If your case goes to trial, the trial is typically going to take about 3 to 8 hours, depending upon the witnesses and evidence being produced. However, your case will be decided on the trial date and concluded on that day. And at that point, after the trial is over, the judge will sign the final divorce decree, and on that day, the divorce is official. And then at that point, either you or your attorney can request a certified official divorce decree from the district clerk's office. So generally speaking, in my experience, it's actually difficult to determine how long a contested divorce case will take. A lot depends on the issues involved, how amicable the parties are willing to be, etc. But on average, I would say they take around 6 months. But they can last for years in some instances, especially when child custody is involved. So now I'm going to pop back over to the comments section. It looks like we had several comments come in. So there is a question here, and I'm not sure if I'm supposed to be reading out the names of the people asking the question, so I won't do that. I'll just say there is a question. And the question is about what are full custody options? Okay, and that's a very, very complex question. Most cases in Texas are done as joint conservatorships where both parents have equal rights, but there are some circumstances where one parent can have what's called sole managing conservatorship. And you would have to discuss that in detail with your attorney or my office because it's a very, very complex question. There's another question that pops up. Thanks for explaining. Oh, that's just a comment. Thanks for explaining the waiver of citation. I understand now. I have another question that says, my petition is already filed and is uncontested. Can you elaborate about the waiver or quitclaim deed? Okay, it says, can you elaborate about the waiver or a quitclaim deed? Well, those are completely two different things. And so the waiver of citation basically is your spouse saying, I agree not to be served with a process server. And in some cases, the spouse will say, I agree for the case to be concluded without any further input from me. Okay, now a quitclaim deed is something completely different, and that's involving property. And so, a quitclaim deed or a special warranty deed is a deed that is used to transfer property from one party to the other, usually for a house, okay? And we do see those a lot in our divorce cases. Again, two completely separate documents. Another question that pops up here is, are you allowed to change lawyers during the course of the divorce? And if allowable, how would it affect the case? Okay, you are allowed always to change lawyers and change representation anytime that you want. But If it's a contested case, I can tell you for sure it's going to slow the case down a lot. It's not as simple as just saying, I want a new lawyer, and then you have a new lawyer. The new lawyer has to actually file documents with the court to be able to become your new lawyer. And in addition to that, the new lawyer has to get the previous lawyer to sign off on the documents as well before those documents are submitted to the judge. And the judge actually has to approve a change of counsel. Okay, another question has popped up. How do you go about discovery if the spouse has a bunch of money in cash? Okay, good question. So during the discovery process, both spouses have to list all of their assets and all of their debts. And in addition to that, they have to swear under oath that the information that they are providing is true and correct. You know, if someone has a lot of money in cash, they're legally required to disclose that information during the discovery process. Now, you know, will someone maybe not disclose? Yes, but that is against the law, and that is a violation. That is a violation of the discovery rules. Next question. A lot of questions. Is it true that if you post a notice in the paper when a spouse cannot be found, you need to wait only 30 days for finalization? Well, okay, and that is going to be called a service by substitute service, and you can post it in the paper. You would have to check with the specific courts for their time frames on how long that notice needs to be listed. From memory, and usually most courts, it's around 20 days that notice would need to be listed in the paper, and then some documents would have to be submitted back to the court to say that it has been listed for that requisite amount of time. And once that's been done, then the party will be considered served. That is an alternate method of service, but usually you have to get special permission from the court in order to use that type of service, because the court wants to ensure that if the party can be served in person, that they will be served in person. Okay, we have another question. My spouse was served with a waiver of citation and non-contested divorce. All right. However, he has not signed it. Must it be signed before the divorce can be finalized? Okay, so I'm going to read that one again. My spouse was served with a waiver of citation in a non-contested divorce. However, he has not signed it. Must it be signed before the divorce can be finalized? Well, from what I'm reading into your question here, it says the spouse was served. Now, if the spouse was served, you know, with a process server, that is considered service. And so technically, the waiver of citation would not have to be signed. But if the spouse was simply just delivered a waiver of citation, then yes, that waiver of citation would need to be signed. But if your spouse was served, then the spouse has approximately 20 days to file an answer. And if the answer is not filed within that 20-day period, then the judge will sign your divorce decree without any further input from your spouse. That would be considered a default hearing. But again, a lot's going to depend on what you mean by the word served. Served by a process server, or just simply, you know, had the document delivered to him by you or someone else that's not a process server. It would depend. Okay, another question. Does my attorney prepare the quitclaim deed for the house property? Yes, that is typically part of a divorce case. And so there would be the divorce decree that is prepared, the waiver of citation. There are some other affidavits and other documents that are prepared as well. But yes, a quitclaim deed is usually part of the process. But actually, as attorneys, we typically use the special warranty deed, not a quitclaim deed. And you can look up the different types of deeds. There are lots of different types of deeds for properties. But as attorneys in divorce cases, we typically like to use a special warranty deed. Okay. All right. Well, let me see if I have any other questions come up here. I don't think I see any other questions popping up. So that is the divorce timeline in a nutshell. We had some very good questions come through, so I appreciate all of the questions. And there are a couple other comments popping up in the chat, and these are from Texas Legal, so please feel free to read those. I'd like to thank you for your time. I hope this webinar has been helpful. Please contact Texas Legal with any questions about this video or information on how to join Texas Legal. If you have any questions for an attorney and you need assistance, please feel free to give my office a call. Again, it's the Chivis Law Firm. Our phone number is 888-253-7002. Again, that's 888-253-7002. And I think our website is popping up there at the bottom of the video as well. I thank you again for your time today, and best of luck with your situation. Bye-bye.